Okay, so we all value our privacy. I mean, when we're talking to our therapist, especially, we're sharing some pretty personal things, and I think we all sort of expect what we say to stay between us and the therapist. But
Yeah.
um, what happens if legal issues come up? Like, what happens to that expectation of privacy if things end up in court?
Well, that's a really good question. And that's really what we're going to be focusing on today, this whole idea of privilege in the legal sense, and specifically psychotherapist-patient privilege. So we're talking California law here. We've looked at both the California Evidence Code and the Business and Professions Code to try to understand all of this.
So we hear the term confidentiality a lot when we talk about therapy. Is that the same as privilege?
Well, they're definitely related, but they're not exactly the same. Confidentiality, that's more of a broad ethical obligation that therapists have to keep their clients' information private. But privilege, this is a legal hearing,
Hmm.
right? It specifically protects those communications from being disclosed in like legal proceedings, like court hearings, depositions, even some administrative hearings. So think of it like this privilege is really the legal tool that protects confidentiality in those really formal situations.
Okay, got it. So the goal for everyone listening today is to get a clear picture of this psychotherapist-patient privilege, right? Like who actually has this, right when they can use it, and also importantly, when it doesn't apply.
You gotta, let's start with who the law says has this power. Who's the holder of the privilege. California Evidence Code Section 1013 spells this out, and for the most part, it's straightforward. It's the patient. But if the patient has a guardian or a conservator, then that person holds the privilege. And if the patient has passed away, then it goes to their personal representative.
Okay, that seems pretty clear-cut. But what about situations where the client is a minor, like a child or a teenager?
Mm-hmm.
Does it get more complicated then?
Yeah, you're right. It does get a bit more complex there. Initially, the legal language focused on guardians and conservators, and that actually raised some questions about, what's the role of the parents. But case law, specifically a case called In Re Side, Daniel C.H. clarified that even when parents are involved in their child's therapy, the child themselves is actually the holder of the privilege here in California. So the law really recognizes that the minor has their own right to privacy, even within their therapeutic conversations.
So even if the parent is the one making the appointment and paying for the therapy, the legal right to keep those conversations private belongs to the child.
Exactly. And when we're talking about children who are dependents of the court or wards of the court, then the California Welfare and Institutions Code, Section 317F, this adds another layer here. So in these cases, either the child or their legal counsel can invoke the privilege, and the child's consent is needed to waive that privilege if they are considered mature enough to give informed consent.
And is there like a specific age where they're automatically considered mature enough?
Well, it's presumed if they're over 12, unless there's like really strong evidence to prove otherwise. So this part of the law really highlights how much the law wants to make sure the child's voice is heard and respects their ability to make decisions in these sensitive situations.
So hypothetically, a 15-year-old who's a ward of the court could refuse to allow their lawyer to disclose something that they talked about in therapy.
Yes, that's right. If the child invokes the privilege, their counsel can't waive it on their own. And the opposite is true, too. So if the counsel thinks it's in the child's best interest to invoke the privilege, they can do that, but the child can still choose to waive it later on. It's a balancing act, trying to protect the child and also respect their ability to make decisions.
It sounds like working with minors and this whole privilege thing requires a lot of sensitivity from everyone involved. So we talked about individual clients and minors. What about when there are multiple people in therapy, like a couple who holds the privilege then?
Good question. That's where we get into what's called joint holders of privilege. And this is outlined in Evidence Code Section 912. So in the case of couples therapy, each person is considered a holder of the privilege. But here's where it gets interesting. One person's decision to waive their privilege doesn't automatically mean the other person's privilege is waived too. So privacy in this context becomes a shared right.
That could get pretty complicated. I'm imagining a divorce where one person wants to bring up what was said in therapy, but the other person absolutely does not want that.
Exactly. And in a situation like that, the therapist would be really careful about disclosing anything without both people giving consent, right? It can be practically impossible to separate what was shared individually versus jointly. And if a therapist discloses information against one person's wishes, that could have serious legal and ethical consequences. And this brings up a question for everyone listening. Knowing that privilege is shared in couples therapy, does that change your view on what should be considered private in that kind of setting?
So the client ultimately has the power to decide whether or not to use this privilege. But what about the therapist? What's their role in all of this when we're talking about legal situations? Are they just kind of bystanders?
No. Not at all. Even though the client is the one who holds the privilege, the therapist has a responsibility to claim or assert or invoke the privilege on behalf of their client. If they are asked to disclose information in a legal setting. So let's say a therapist gets subpoenaed to testify about their client. They should immediately inform the court that they're claiming privilege for their client, and they should only disclose information if the court orders them to or if the client gives consent. So they're like a guardian of the client's privilege, unless the court or the client tells them otherwise.
Okay, so this privilege is a really important protection for the client, but we know that almost nothing in the legal world is absolute. Are there exceptions to this privilege?
You are absolutely right. There are definitely some very specific legally defined situations where the psychotherapist-patient privilege doesn't apply. And broadly, these exceptions fall into a few categories. We have client consent. If the client agrees to share the information, there's legally mandated reporting, like if there's suspected child abuse or elder abuse situations where the client has already shared that information with other people. And then there are some specific exceptions that are outlined in the California Evidence Code itself. And it's worth noting that in most of these cases, a judge is going to review the details of the situation to decide if the exception is valid before ordering any disclosure.
So let's get into some of these specific legal exceptions. The first one that comes up in the materials is the patient-litigant exception, which is under Evidence Code Section 1060. What's the main idea behind that one?
The idea here is to make sure things are fair in legal proceedings. So this exception basically says that if a patient files a lawsuit or brings up their own mental or emotional state as part of their legal claim, then they might lose the privilege related to that information. So for example, if someone sues for emotional distress after a car accident and they claim that they now have anxiety, well, the therapy records that are related to that anxiety, those could be considered discoverable because by bringing up their mental or emotional state in court, they essentially give up the right to keep those conversations private.
That makes sense. If you're saying I've been emotionally harmed, then the information about that harm becomes relevant to the case. So what about when a court orders a psychological evaluation? Like, does that information have privilege?
That's covered under Evidence Code Section 1017A, which is the court-appointed psychotherapist exception. And generally, if a therapist is appointed by the court to do an evaluation, like to assess if a defendant is competent to stand trial or to figure out their sanity at the time of a crime, the communications in that evaluation, they are not privileged. But there's a really important safeguard here. The therapist has to tell the person being evaluated before the evaluation even begins that anything they say won't be confidential. And if they don't give that warning, the evaluation could be thrown out in court. So making sure things are transparent from the beginning is key.
That warning seems super important to protect the person's rights. So what happens if it's the defense attorney who asks for the psychological evaluation for their client? Is that treated any differently?
Yes, it is when the court orders an evaluation because the defense attorney asked for it. The reason behind it is different. It's not about getting an objective assessment for the court. It's more about giving the attorney information to help them come up with a legal strategy. Maybe they're considering an insanity defense or trying to understand their client's state of mind related to the charges. So in that case, the things that are talked about during the evaluation, those are usually privileged because the goal is to help the client with their defense. So the main difference is who asked for the evaluation and why.
Okay, so the reason for the evaluation really matters.
Right.
Let's move on to the Board of Prison terms. There's an exception there as well.
Yeah.
Right?
Yes, that's right. Evidence Code Section 1017B covers that one, and it says that there's an exception to the privilege when we're talking about a therapist who is appointed by the Board of Prison Terms to evaluate an inmate. This is often done to figure out if the inmate needs mental health treatment, and this is usually related to things like maybe the inmate being eligible for programs like the Mentally Disordered Offender Program that's under the California Penal Code 2960, but the main point is that in these evaluations, the main goal is to assess the inmate's mental health for the board to make decisions, and so because of that privilege does not apply.
What about situations where someone is going to therapy not for help but to do something illegal or dishonest? Is there an exception for that?
There is, and that's a good question. It falls under the crime or tort exception, which is Evidence Code Section 1018. And so if a person goes to therapy or uses therapy to help them commit a crime or like a civil wrong, which is a tort, or to plan one, or even to try to avoid getting caught after the fact, the privilege doesn't protect them in those situations. So, for example, let's say someone is faking a psychological problem to get insurance money and they talk about their made-up symptoms with the therapist. Well, the conversations about the fraud, those wouldn't be protected by privilege if there were any legal action related to that insurance claim. So the law is basically saying we're not going to protect communications that are part of criminal activity.
Right. The legal system is not there to help people plan illegal things.
Yeah.
Okay, so another exception is when there's some kind of disagreement or dispute between the therapist and the patient themselves.
Yes, that's right. That's the breach of duty arising out of psychotherapist-patient relationship exception. And that's in Evidence Code Section 1020. So if either the patient or the therapist files a lawsuit against the other one, and it's related to the therapy itself, so maybe the patient claims malpractice or the therapist is trying to collect unpaid fees, then the privilege is waived for any information that's needed to defend that claim. So the patient can't use privilege as a shield to stop the therapist from defending themselves if they're the one who brought the lawsuit in the first place.
Okay, and is there a specific exception when a defendant's sanity is the main issue in a criminal case?
Yes, there is. It's covered under Evidence Code Section 1023, which is titled Proceeding to Determine the Sanity of Criminal Defendant. And so if a defendant says that they were insane at the time of the crime, for instance, if they plead not guilty by reason of insanity, then they can't claim privilege for information about their mental health. The court needs to be able to see all the relevant psych evaluations and records to determine the defendant's mental state at the time the crime allegedly happened.
Okay, so a lot of people probably think about the exception that applies when a patient might be a danger to themselves or others. How does the law address that?
That's a crucial exception, and it's covered under Evidence Code Section 24. It's often called the patient dangerous to self or others exception. But it's really important to understand that this section says that disclosure is allowed in specific circumstances. It doesn't always mean that the therapist has to report every time a patient says something about suicide or homicide. So the law says that privilege doesn't apply if the therapist has a good reason to believe that the patient is a danger to themselves or other people or their property, and that sharing information is necessary to prevent that danger. So if a therapist, using their professional judgment, discloses information to stop someone from getting hurt, then they can talk about that in court later on if they need to. For example, if a client makes a serious threat to hurt someone and the therapist warns that person, the therapist can then testify about that threat in court if they have to.
So it's about preventing someone from getting hurt right now, and the law says that the need to protect people is more important than keeping things confidential in those specific cases. So what about situations where there are concerns about whether someone is able to manage their own personal affairs?
That's covered under the proceeding to establish competence exception, which is Evidence Code Section 25. And this basically says that if there are legal proceedings going on to figure out if a person is competent, meaning if they're able to make good decisions about things like their finances or legal matters, then they lose privilege when it comes to information about their mental capacity. So if a psychologist has evaluated that person to see how well their mind is working, then they might have to testify about what they found, and they wouldn't be able to claim privilege in that situation.
Okay, and the last exception that we have here, this has to do with young patients who might be the victims of a crime.
Yes, exactly. Evidence Code Section 1027 says that there's an exception when we're talking about a patient who is under 16, and the psychotherapist has a good reason to believe that the patient has been the victim of a crime, and disclosing confidential information is in the best interest of the child.
Uh-huh.
So, for example, if a 13-year-old tells their therapist that they are being sexually abused, the therapist might be required to report that to the authorities. And this section of the law makes it clear that privilege does not prevent the therapist from sharing that information if it's part of legal action to protect the child.
Wow, that's a pretty long list of exceptions. It really shows that even though the psychotherapist-patient privilege is really important, it has to work within a system that considers other legal and societal interests like public safety and protecting vulnerable people.
Yeah.
Now, the materials we looked at also included some practice questions that dealt with the ethics code and privilege. We're not going to go through the answers here, but why were those questions included?
Those practice questions, they were there to show how these legal ideas about privilege connect with the ethical rules that therapists have to follow. So they really highlighted how complicated things can get for therapists when they're trying to figure out these situations. It emphasizes how important it is for therapists to really understand informed consent and to know who holds the privilege in different cases, and also to be able to recognize when those exceptions might apply. It's a constant learning process for mental health professionals.
So to sum things up for our listeners, the psychotherapist-patient privilege here in California, it's really important for protecting privacy and therapy, but it's not unlimited. There are a lot of specific situations when it doesn't apply. The patient is usually the one who holds this privilege, and the therapist has a duty to try to use it on behalf of their client.
And it's important to remember that confidentiality and privilege, they aren't exactly the same thing. Confidentiality is an ethical obligation, but privilege is specifically a legal right that's used in legal situations.
So here's something to think about, given all the details and exceptions we just talked about. How does this understanding of psychotherapist-patient privilege change how you think about privacy in any relationship where you might share sensitive information, not just with a therapist? It really makes you consider that balance between expecting privacy and those situations where the law might actually allow or even require information to be shared. We hope this deep dive has given you a good basic understanding of this important topic, and we encourage you to look into any specific legal situations that might apply to your own life or your work.
Yeah, I think that's a great point to end on.
Thanks for listening, everyone.
See you.